Hello, everybody.
People versus Anthony Johnson.
Yeah, Sharon, I'm here.
And Ms. Schlussel.
Good morning, Your Honor. Deborah Schlussel on behalf of the defendant, Mr. Anthony Johnson.
And
Your Honor, I know Ms. Manarino met with Ms. Schlussel. I'm not sure what the disposition was, so but I'm here.
Your Honor, the court's memory. We were here with the court on April 24th. At that time, I told the city's council that there was nothing in the police report that did not appear to be any case. And if there was anything showing that my client signed anything or anything was actually deposited, we would like to see it. We were told it would be sent to us. Then we were here on June 24th. We still did not have it 2 months later. Your Honor told the city that if they did not serve us with that documentation by July 3rd, that you would dismiss this matter. We received that material at 2:42 p.m. yesterday. So we are asking that this matter be dismissed with prejudice because we did not get it by July 3rd. It's been months. And I was told by Ms. Manarino that I have no manners because I asserted this to her. So, Your Honor, I may have no manners in her opinion. I think I have pretty good manners, Your Honor. But regardless, I am asking this matter be dismissed with prejudice because the material was not given to us till 2:42 p.m. in an email yesterday.
Your Honor, can I address this, please?
Sure.
Sure. I was not in the breakout room with Ms. Manarino and Ms. Schlussel, and I was not here at the prior court date that Ms. Schlussel was here with regard to that case. My understanding is that it was not July 3rd, that it was July 7th, which I produced it yesterday. However, I only produced it because we had not heard from Ms. Schlussel since the beginning of this case. On February 20, unbeknownst to the court, at the time that this was represented on the record, on February 25th, 2025, this office, the prosecutor's office for the city of Taylor, has a regular pattern and practice of producing discovery immediately to attorneys to get whatever it is they need. So whenever they ask our office, my office, me and Ms. Manarino, for discovery, we immediately, without a court order, provide a copy of the police report and a discovery order to be entered with specific directions and fax number to be sent to the Taylor Police Records Department to obtain whatever it is the police department has with regard to this file. The reason why we set it up that way is because, as this court is aware, 90% of the time, all the attorneys really want to see is the police report and see the narrative on what's going on. And they don't want to go through the process of obtaining videos and all kinds of stuff that's there. And that's why we provide them with the same standard discovery order to obtain whatever it is they want to do. So this was done, and I have an email to Ms. Schlussel on February 25th, 2025, with the police report, which provides what we may or may not have in it, and a court order to obtain whatever it is she wants to do. All right. And then after the last court date, which was June 24th, on June 26th, there is an email. Good morning, Ms. Schlussel, forwarding the February 25th email saying, following up on our discovery request. Here's the email that we sent you previously. Here's another copy of the report in the discovery order. What is it that you're looking for, or whatever it is that you need? Then yesterday morning or yesterday afternoon, I sent an email to Ms. Schlussel because I'm following up, and I say, hey, what's going on? Do you have everything? Do you not have everything? I don't know what's going on. No, nothing, no response. All right. So I went through the file again. I talked to my staff and I said, look, we haven't gotten anything. We're more comfortable with the discovery order being entered because a lot of times there's personal identifying information. There's stuff like that the city and everybody is protected with regard to disclosure when there's a discovery order. And I looked through the documents from the bank, from Total Community Credit Union, and I determined, all right, you know what? I'll just forward this over because we have not heard a response from Ms. Schlussel since February.
All right, so I did have.
You're on mute, Debbie.
Ms. Schlussel, you are muted.
Your Honor, with regard to all of that, regardless of an email chain asking me things, the email chain really revved up in the last few days. You said on the record everything was to be turned over to me by July 3rd. It was not. And you said you would dismiss this matter if it had not been. I'm sorry, Your Honor. Go ahead.
Well, I just wanted, because I specifically wrote it down. I said, plaintiffs to give discovery to the defendant on or before 7/3/2025, 7/8/25, motion to compel discovery / to dismiss. So today was the date and time for a motion to compel discovery and or for a dismissal. If you hadn't got, now last time when you were here, there was nothing specific requested to the court, just that you hadn't gotten discovery. So if there was,
Your Honor,
if there was an email that was there, and then if there was something more specific, Mr. Greco is saying that he said there's an order there. If there's something more specific, tell me what the more specific thing is. So
Your Honor, I specifically said on the record last time that on the 24th, we had asked Ms. Manarino, all we have is a 1-paragraph police report. It has no proof of anything. And as far as I'm concerned, my client didn't do anything. If you can produce the checks that you claim were deposited and show my client's signature, we would like to see them. Ms. Manarino told me she would get those to me before the next court date. She had 2 months. Nobody said, oh, but you know what? You have to go back to our email in February and go through this procedure. She said she would get it to me. If she had said, oh, I can't get it to you until you do this, this, and this, I would have done it. She didn't say that. She said, I will get it to you before the next court hearing. She had 2 months. At the last court hearing, we did not have those checks. I put that on the record. Ms. Manarino said on the record that somebody in the office was supposed to provide it, and they didn't. So, Your Honor, I was very specific about what we wanted, which was the documentation of what they claimed in the police report, which we didn't get. Your Honor, they didn't produce it by July 3rd, and I'm asking that this matter be dismissed with prejudice. They didn't comply with what you said. It was not 7/7, it was 7/3, and I did ask for it April 24th. I was assured by Ms. Manarino that it would be forthcoming, and that she would send it to me. And again, on the record, she represented to the court on June 24th that somebody in the office was supposed to send it and they didn't. So now we're going back and telling me, or the other side is going back and telling me that I should have responded to emails in February, or I should have responded to emails from yesterday when I was in court all day and I had something due by midnight last night. I didn't see their emails till late yesterday after the close of business. But regardless, none of that is relevant. What is relevant is that I asked for these on the 24th of April. I was told they would be forthcoming on the 24th of June. I said what I did not get, which was the check documentation, because my client is accused of depositing false checks or something of that nature. And you told them to get it to me by July 3rd. They didn't get it to me. I already had the 1-paragraph police report, which has nothing. I mean, there's no proof of anything on there. There's no case on there. And as we know, police reports are not exhibits. They're not evidence. So, Your Honor, I now to backtrack, for them to backtrack and say, oh, I should have responded to something in February, or I should have done this or this, when I relied on the prosecution's assurance on April 24th, months ago, that it would be sent to me. And then on June 24th, when the representation was made to the court that the person who was supposed to send it didn't do it. Now all of a sudden it's my fault because of something back in February or emails yesterday. Come on now.
Your Honor, if you can see the shared screen, 2 days after the June 24th court date is the email to Ms. Schlussel.
Yeah, and it does state that the order is there. If you want to give permission to sign your name to it,
We'll enter it for her.
And
get it. Sorry, Joe.
So here's the thing. What I'm looking for is there any prejudice? All right, and I'm going to set this. Obviously, it seems like Ms. Schlussel is indicating, and zealously so, as a good attorney does, that her client is innocent. And so I'm going to set this for a trial. The next trial date that I even have available wouldn't be until probably the end of September. So if you have these checks, you say that the checks came in the email yesterday?
Yeah,
Yes, I received them yesterday, but Your Honor,
Sure.
Your
Then
Honor,
there's not going to be any prejudice to either party, especially to the defendant here, because he has a zealous representation with Ms. Schlussel representing him. They have the discovery that they're going to need for the trial to prepare for it. I'm going to set it up for a pre-trial a week before the trial. So, and if there is anything else, Ms. Schlussel, do I have your, actually, is there an order in the file?
No, she hasn't given us consent to sign it, so she could get anything that she wants.
So if anything else needs to be, is there anything else that needs to be given to either party?
So, Your Honor, I would argue my client has been prejudiced because this case started in February, Your Honor, in February. And we've come to multiple court dates. And, Your Honor, this has been months and months and months. It's been half a year. And, Your Honor, you did order them to produce everything by the 3rd. There was nothing about I have to sign an order. You ordered them to produce it, and they didn't. So, Your Honor, I think my client has been prejudiced. And now to wait till September, 7 months later, or I'm sorry if my math is correct. Yeah, 7 months later. Now it's July. It's 5 months later.
So,
Your Honor, I don't think that is, I don't think that that's fair to my client because he's shown up. And you didn't say anything about I have to sign an order. You ordered them to produce it.
Ms.
Just
Schlussel
like on April 20th.
all this stuff by the first week of March.
Wait, I'm sorry, I'm talking. I didn't interrupt you. So just like on April 24th, when Ms. Manarino told me she would send it, and just like on June 24th, where she represented to the court that the wrong person didn't send, or the person who's supposed to send it to the wrong person or didn't send it to us. Now all of a sudden I have to sign an order. They never brought that up before. They said they'd get it to me. So now they're relying on this paperwork when you ordered them to send it and they didn't do it. And you did say that if they didn't serve it on me by the 3rd, which they did not do, then this would be dismissed. And they didn't do it.
No, I didn't say I would dismiss it. I said I'd set it for the 8th for a motion to compel discovery / dismissal. I literally have the notation right here on the file. So
okay, so that's my motion, Your Honor. I'm moving that this should
sure,
be
I
dismissed.
understand that. And I find that there would be no prejudice. With regard to a court date, I have, let's see. Is this going to be a bench trial or a jury trial?
So, Your Honor, now that I have it finally, I would like you to set another retrial soon so that maybe we can work this out soon to be fair to my client since he's waited for months.
Sure, you guys, I want you to be able to take a look at it. You said you got it yesterday. So how about we have a pretrial next week? Next week or the 22nd, one of the two, 15th or the 22nd.
Whichever one's good for Ms. Schlussel is fine with me.
Your Honor, the 22nd would be good for me.
All right, so we're going to set this for the 7/22, and that'll be at 8:30. We'll see everybody then. And then as far as the trial date, is that going to be a bench trial or a jury trial?
Your Honor, I'm not sure at this time. Can we wait to decide that until the 22nd?
All right, not a problem. I was just trying to look at potential dates. So let's still look at potential dates. How about August the 11th?
8:11 or what for the
It
trial?
would be at 8:30. It would be at 8:30 in the morning.
Eight
So-
for the trial?
Yeah.
Your Honor, I do have a brief 9:30 sentencing on Zoom with Wayne County Juvenile Court. If we could do it after that, that would work for me.
Sure. I just set it at 8:30. If you need to step aside, go into one of the private rooms here, and I don't know if you're doing it by Zoom, right? So like your phone.
Right,
would be
at
fine.
9:30.
Yeah. And that way, if you guys worked it out, I just want to start something, get a date going so that I can mail out. And if Mr. Greco's available, I'm available on Monday mornings. And then this is why I keep the Monday mornings flexible like that.
August 11 works.
Judge, you're not here August 11th.
Hang on a second. How about August the 18th?
So, Your Honor, I think we have evidentiary hearings that morning for environmental wood.
Check.
I think you're scheduled for 10 a.m. I think we're booked that morning. I think those were specifically scheduled.
Yes, 10 o'clock.
About August 25th.
So far, there's nothing scheduled.
How about August 25th?
Let me check 1 second, Your Honor.
And if it's going to be a bench trial, I have a lot of other dates that'll be open to availability. So you don't have to pick that today, but on the 22nd, if you know.
So, Your Honor, I do have a big
Oh,
trial in circuit
no.
court.
Yeah, you know what? Actually, I do have a conflict on the 25th. That's one night that I can't get out of.
Do you have the 19th available, Your Honor? Or the 21st? Or the 12th or the 15th?
I have other, as far as the 19th, I guess the only thing on the 19th I could do would be, let me see if that's already scheduled out that far. August 19th.
Here, you know what? One say.
Yeah, I
can't-
could do, all I have is one thing set on in the afternoon. That's just a priority waste. Civil and yeah, misdemeanor and civil infraction. So I could set it at 1:30 on
Okay.
the 19th.
August 19th.
Yeah.
I'm available on the 19th.
I can do it.
All right, so
All right, so
1:30 on August 19th.
Yep, I'm gonna set up a trial on the 19th of August at 1:30. Actually, I'll just set it for 1:15. So everybody's here and ready.
Yeah, that's fine.
Okay, of
And that's in person. I'm gonna put in person on there.
course.
And if it's gonna be a bench trial, it'll be a bench trial. If it's gonna be a jury trial, it'll be a jury trial.
And Debbie,
So
call me
motion-
this week or next week. So
Okay,
Motion.
I will.
Motion to dismiss is denied. I don't find that there's prejudice. And motion with regard to the discovery. Ms. Sussel, do you have everything you need now? I mean, is there
I
anything
believe I
left?
do, yes.
Okay, so there's no need for me to sign any other ordering discovery?
you know, Ms. Schlussel, what we're going to do is I'm just going to sign your name to the order that we have. We'll have it entered and we'll get it to you just in case there's something that comes up that you need.
Okay,
All right, and let the record so reflect that. And then we'll see everybody on the 22nd.
thank you.
Thank you.
All right.
Be safe, be well, sleep sweet, and much love.